Hello, everybody. I hope you can all join in and see us all, and welcome to the second of our webinars on common repair issues for private landlords. As you'll know, these webinars are supported by the Safe Deposit Scotland Charitable Trust. We're so grateful to all of their support, and it's not just financial, it's moral and it's practical as well. So just a quick bit of housekeeping. You may have seen some of this in the waiting room, but you'll see on the right-hand side at the top of your screen some buttons saying chat, Q&A, polls and handouts. Now, you can use the chat at any time to tell us if you're having techie problems or make a comment on what any of the speakers are saying. And please just sort of check in and say hello and where you're from and how many properties you own or how many properties you manage. It would just be nice to say hello to all of you. You'll see next to the chat, there is the Q&A. And any questions that come up there, we will answer at the end of this webinar. And you will also see handouts with a red dot beside it. If you click on handouts, you'll see a number of handouts have been provided by the speakers. And this week we are all singing and all dancing because we're going to have a poll as well. So we're really testing our capabilities here today. Let's hope we don't break things. Now, one of the things we do is that we pre-record all of our presenters and the conversations that we have, because it's not just a bit of a safety measure, but it also means that we can sit behind the scenes and chat with you, and we can see what questions you're coming up with. So it just helps us be just a bit more interactive over everything. So the three speakers I have today, and I'm kind of going to do this, so it's not quite a beauty contest, but I'm going to do it in reverse order, the classic way. The last person that we've got speaking today is Robert Storey. Now, Robert is a structural engineer who I have worked with in previous existences. And Robert does training for people on health and safety on building sites. And this is something where there are particular rules that you need to be following. And in fact, one of the things we're finding is that landlords and owner-occupiers may be less different in their responsibilities here than we thought. Our second speaker is Simon Roberts. Now, Simon is from Scottish Government, and Simon's responsibility is for housing quality and housing standards. And he's going to talk about the link that there is between the repairing standard and common repairs and just the interaction that there is between these two things. I know it's something a number of people have asked us about before. And our first speaker is going to be Dorothy Ogle, and Dorothy is from the Scottish Government as well. And Dorothy has been looking at the revised code of conduct for factors, and it was just in the middle of all of this work that there was a particular court case that came up that changed how we perceived what a factor should be, or what the definition of a factor should be. Now, those of you who are members of the Scottish Association of Landlords, or who have maybe looked at some of the articles on Under One Roof, will have seen that we do have these articles about our landlord's factors. And one of the reasons for that was that the way the Act defined a factor happened to mention people doing it in the course of business, without really defining what that course of business was. And this court case that Dorothy and I will talk about just threw that definition up in the air. And Dorothy has now been trying to pick up the pieces here. So we're going to go first to the conversation with Dorothy and flow straight through all the other speakers. And I have got Petra behind the scenes here who is going to cue that video. Are you able to get us there, Petra? There we go. So without further ado, let's go and hear those conversations, and we'll all be getting on the chat. See you soon, folks. So I would like to welcome Dorothy Ogle. Now, Dorothy works for the Scottish Government, and one of her jobs is to examine what the Property Factors Code of Conduct should say. And there's been a case recently which has changed what we think about who should be defined as being a factor. So, Dorothy, I wonder whether you could start off by saying, what was the position before? Why was it that landlords were concerned about being registered as, or having to be registered as being a factor?
Okay, so the definition of a property factor is set out in the Property Factors Scotland Act, which was passed in 2011, and that set out actually 3 different sort of descriptors for factors. The most relevant one was that you are a factor if in the course of business you manage common parts of a building. And obviously the main group of people that was intended to capture there was property factors whose main business is managing and maintaining common parts. But because of the terminology in the course of business, that could be in the course of another business, for example, as a landlord or as a property developer. So some landlords had been concerned that if they undertook maintenance of a building where they owned a property, they might be found to be property factors. But because the Act also sets out requirements to register as a property factor and to follow a code of conduct, and there is recourse to the tribunal if you don't follow the code of conduct and a homeowner takes you to the tribunal. But in addition, there's a criminal offence of acting as an unregistered property factor.
These situations, Dorothy, they're not very frequent, are they? We need to make it clear to people that we're not talking about situations where you've got a tenement or a block of flats and you've got a regular registered factor. That it's not that situation. This would only apply where people are either unfactored altogether or self-factored maybe, or where they've got some other kind of arrangement, isn't it? You know, those are the situations we're talking about, isn't it?
Yeah, so the Proven judgment doesn't really have any impact on mainstream factors because they do, in the course of their main factoring business, that they're already captured. What it has done is eliminate people who were providing a factoring service, but whose main business was something else.
So on the face of it, Dorothy, that was actually good news for landlords, wasn't it? Because it made it quite clear that if they carried out a common repair to make sure their flats were properly maintained, they weren't acting as criminals. I mean, that was good news for them, wasn't it?
I think it does. It does give an absolute clarity. Having said that, in the property factor team, we weren't pursuing lots of landlords to be registered. It wasn't a. I think that the fears that were there were not necessarily concerns that were valid. But here the law has been clarified by that judgment. It's less good news for property owner.
Okay, so why is it not such good news for property owners then?
In the situation where you have a majority owner who would probably be a developer or a landlord to be owning more than half of the properties in a development, it leaves minority owners in a very difficult situation because they can never win a vote. They have very limited then recourse if they don't think that repairs are being carried out to a reasonable standard, or they disagree with the majority owner, and it leaves them with nowhere to go really, because they can't go to the tribunal anymore.
Yeah, and there might be other situations too, like there, where a company says, "Well, look, I'm not a factor. I'm a maintenance company. I will go and do everything you ask. I will blast ahead and do it, but I won't charge you a management fee. I'll get my income elsewhere. I'll charge a percentage on repairs." And if something went wrong with a case like that, the only option you'd have would be to take that person to court.
I think that case would have to be tested separately.
So, but it does illustrate why you really want to make this totally clear.
So we're re-looking at the definition in the light of this interpretation to check. And there are a number of anomalies that it creates, really. One is that, there will be people who you might expect to be captured by the definition who wouldn't be. So, for example, a developer who has had a building, who is building a number of flats and is acting, to all intents and purposes, as a factor, but because they don't have a separate factoring arm, that would not be judged to be the course of their business.
And I think, Dorothy, you're very keen to hear from people who are in more unusual situations, aren't you? And the way people could get this information too. And I should say, we do need to get this done quickly because the consultation has officially ended, but Dorothy's kind of keeping it open for us until the end, just about the end of the webinar, I think, isn't it, Dorothy? So you could either use the chat to sort of type in if you've had any of these odd experiences or situations you want Dorothy to hear about, or you could email her directly after the end of the live webinar. So I'm afraid if you're watching this in the recording, it's too late. Very sorry about that. When you come to re-examine all of this, Dorothy, post the Proven case, you've got this kind of option about what you're going to do about changing the definition of being a factor so that it's including all the people who are acting as factors, even if they don't say that they are factors, and who are doing it in the course of business. But you do want to be careful that you're not bringing in everybody, that you're not bringing in landlords, that there ought to be some defined set of exclusions from this to make it quite clear to those people that they are excluded. And what we've done is we've put the potential list up as a poll. And if people click on the polls tab up at the top right hand side of their screen, they'll see the poll there. And what we could do, Dorothy, we could talk people through that, couldn't we?
Okay, yeah.
Right. So the first exception we've got, I think everyone's going to tick this. Well, maybe some wouldn't, but it's to exclude individual owner-occupiers.
Yes.
I suppose there will be some people who think, look, you're going to have some totally incompetent person. Everybody ought to be factored. And I suppose if you feel like that, then you could just say, no, leave that one blank.
Yes. Well, I guess you will have situations where you'll have someone in a stare who's taking the lead on organising the factoring. And, there may well be other people who think that they ought to be, held to the same standards as a factor. Mm. But the point in that situation is that you will have a majority vote to decide on money that's spent. So there is a mechanism for other people to sort of enter into discussion and to disagree.
Yeah, okay. And if we are going to skill up owner-occupiers to be better at carrying out repairs, this is not the way of doing it, really, is it? We need to...
Exactly, yeah.
Okay. So the second potential exclusion is where you've got owners associations who are self-factoring. Let's just talk through that one and what the implications of excluding that group is.
So in actual fact, I think because owners associations don't exist as a separate legal entity, the fact that we've excluded owners probably means that we would already be excluding owners associations, because in effect one owner would be acting on behalf of the others. But we wouldn't want to place the sort of the burden of complying with all of the duties in the code on an owners okay when we're really keen to encourage people to maintain their properties as much as they possibly can. Right.
Okay. And then the third option we've got is of anyone who is carrying out property maintenance on a kind of irregular basis. They're just fixing the roof as and when it leaks. They're not undertaking regular stair cleaning or helping with common insurance or things like that.
Yeah, I think this probably links into whether you're actually managing common property or whether you're just doing infrequent bits and bobs of maintenance.
Yeah, and this would probably mean that landlords would be excluded where they're in an unfactored property and someone has to get on with the job, and often it's the landlord that will actually pick this up because they've sometimes got more at stake in some ways.
Yeah.
The next option for exclusion is anyone who's not actually charging or recovering a cost. So by recovering, we mean people who say, well, I'm doing a repair, but I'm going to charge 10% of the cost.
Mm-hmm.
So or exclude anyone who makes a charge in any kind of way.
Yes, or charging for if people aren't recovering any costs from other owners, then there's not so much of a case that owners need to take that would need to be able to challenge that person's decision.
And the final option is where is to exclude anybody who's acting where they've got the majority of owners agreeing that they should act, as long as that person themselves isn't that majority owner. Do you want to just explain that one briefly, Dorothy?
Yes, that's right. So this would be where a landlord or a developer might have agreed through the tenement management scheme to undertake some work on behalf of owners. But we would want to make provision, I think, for a situation where that landlord or developer is the majority owner, because that gives rise to this sort of unfairness where the remaining owners in that block basically won't have a say in the management of that development.
Okay, thanks, Dorothy. And to anyone who's got this poll open, yes, please choose your options, and don't forget to add some stories if you have any on the chat. And I'll say thank you to Dorothy just now. Thank you, Dorothy. I think that was really helpful, and I think it's really good that you've been here to give landlords a chance to have some say in this. And you'll be coming back, I hope, for the Q&A. And while Dorothy may not be on your screens and we're talking to other people, she will be able to see what you're saying. And like I say, if you do want to get to her individually through her email address, please do it quickly, tonight, even after the live webinar. Thanks very much, Dorothy.
Thanks, Annie.
At this part of the webinar here, I would like to introduce Simon Roberts. Now, I've known Simon for a long time, and he has been my go-to person in the Scottish Government, and his job is to deal with housing standards and housing quality. And I think the other brilliant thing about Simon is that he's got a diploma in housing. He has studied housing. I think he's the only person in the Scottish Government who's got that qualification. And I think the other interesting thing for landlords today is that Simon's dissertation was actually about how politicians see landlords. Simon, what did you find out when you did that dissertation?
Well, I was very interested in the way in which the idea of the bad landlord was used in the kind of political rhetoric. There was always a minority of bad landlords. And then this was being used by politicians, but also by, say, groups that represent landlords who are keen to say our members aren't like that. So I was interested in this, and I looked into the history of it. And what I found particularly interesting was that there are periods in history where you would expect to find landlords blamed for poor quality housing. If you look at, say, the awful condition of housing, all that evidence that's collected, say, in Engels' book on the condition of the working class and the dreadful housing people were living in at the beginning of the 19th century, nobody ever blames the landlord for that. And it's the same in the novels of the period, Gaskell's Mary Barton or Disraeli or Dickens or anything like that. There's no sense that the landlord's at fault because the housing is bad. It's just not even considered. And as we move into the 21st century, government changes its attitude, and it wants to see the landlord as a responsible person, and to look at how you can help landlords to work and work with them, because they want the sector to grow. They want people to be responsible. And a lot of the language that's being used about antisocial behaviour, about small minority undermining the cultural values of the majority of people in that sector, becomes dominant in the political discourse. And I was just interested in how that developed. There we are. That's what it was about.
Yeah. Well, I mean, I know that every landlord who is going to be listening in on this is going to be a responsible landlord.
Yeah.
You know, and I think all the landlords that I've met, as far as I know, have been responsible landlords. But, you know, I do find
I think the big takeaway is that talking about bad landlords isn't particularly helpful. It hides the structural problems about the difficulties people have investing and improving property. And that's where we are just now.
Yeah. And I think it is quite hard to try and convince owners of that sometimes.
Yeah. And there's every reason why a landlord would want to look after a house. That's their investment for the future, their income. Why wouldn't you want to take care of it?
Yeah, absolutely. So, I mean, I think it goes without saying, Simon, that we're not going to have a landlord listening who doesn't know what the repairing standard is, but maybe we should just do a quick recap for them.
Okay. Well, the repairing standard is the statutory minimum standard that a private landlord should ensure their house meets before they let it and throughout the period of the tenancy. It covers a wide range of things. I think for our interest today is where it covers things that would be part of the common parts of a tenement, like the external structure, the rainwater goods, and so on. There is an amendment to the repairing standard that's due to come into force in 2024, and that will add in rules about common doors and common access. So that will expand the range of things that directly touch on issues that are likely to be matters that require the cooperation of all the owners in the building.
Okay, so it's the repairing standard will cover most aspects of what everyone would term as being common repairs, because it's everything that a tenant can access. But
if the tenant's use of the property is affected by the disrepair to that part of the building, then it comes within the scope of the repairing standard.
Okay. Now, I've had lots of landlords come to me and say, look, they've been really concerned what's going to happen if common repairs aren't carried out. You know, they maybe own a top floor flat. What might happen to them if common repairs aren't carried out and their tenants affected?
Yeah. What happens with the repairing standard, if a tenant feels that a landlord hasn't done work that they should have done, they can go to an independent tribunal, the first tier tribunal for Scotland, and they can ask for an application from that tribunal, can look at the case, and if they think the landlord should do the repair, they can issue a repairing standard enforcement order. They're not going to do that though if the landlord genuinely cannot carry out the work. For example, there are rules in there for if you require consent, you maybe need to go to another flat to do the work, and the owner of that flat won't allow it. And the same would apply. We've made this clear in the legislation recently. The same would apply if you can't get the other owners to give you collectively the permission to go out and do the work in the building. So you wouldn't be at fault for not carrying out a repair if you couldn't carry out that repair because you just can't get the agreement of everyone in the building, which you need to be able to carry on common works. Okay,
so I suppose there's a couple of situations I just want to explore, make sure there aren't any grey areas for people here, Simon. So if you have an owner who, say, lives in the top floor flat who won't allow access for repairs to be carried out, and your tenant's affected it in a different way, say, then you're okay. You've been blocked from carrying out common repairs.
Presumably you'd want the work to be done, but you can't really be held liable for something that you can't do.
Okay. And if you're trying to get common repairs done, but you can't get a majority of owners to agree, then you wouldn't be responsible then?
No.
Okay. No one could argue then that you should be using the duty to maintain or something like that to force.
Well, I think that's that. Yeah, you mean like the emergency works and so on. No, I mean that only really applies if it's a genuine emergency and it's only just to make good the work. You can't really say a landlord has a wider responsibility than other owners for carrying out common works, except that broadly speaking, you would expect them to be in favour of works which are necessary to comply with the repairing standard.
Okay, so I mean, there have been questions from landlords to us saying that, you know, they're struggling to get common repairs carried out.
This is the case.
Who's blocking those repairs is another landlord.
Right. Yes.
So can a landlord be forced to carry out common repairs in any kind of way?
Well, the tenant has the right to challenge the landlord, and the local authority has the right to apply to the tribunal on behalf of a vulnerable tenant. Other people don't. You or I can't go to the tribunal and say, Mr. Smith, the landlord, hasn't done what he should do to the repair standard. It's only someone who is the tenant or the local authority acting on behalf of the tenant who has the right to raise those concerns. And it's only the tribunal that ultimately can decide that a landlord hasn't met that standard.
Okay. So just to sort of kind of recap on that, if you are a landlord or you're an owner and there's another landlord in the tenement who isn't carrying out common repairs,
yep,
and is blocking things, it's not going to affect the repairing standard.
Not for you, no. You might want to raise it with the local authority who might want to do something about it, but you really can't do anything as long as that other landlord is refusing to give consent to the work.
Yeah, and if you want to get something done about that landlord who's blocking things, then you can go and ask the local authority to do what do they call it? Is it third party reporting?
Third party reporting, yeah, which is discretionary. They don't have to do it, but if they accept there's an issue there that someone's been left in poor quality housing because the landlord won't take action, they can articulate those rights on behalf of the tenant.
Okay, I think most landlords would find that very, very reassuring, actually, that basically, you know, if they can't get common repairs done, they're not going to be penalised through the repairing standard or through having their landlord registration withheld. Yeah. I mean, if they were at fault because they didn't cooperate with a repair, or they didn't do a repair they're supposed to do and there's repair standard enforcement order, that would be a matter the local authority could take into account in renewing the registration. But the situation where they're just, with all the best will in the world, they're just unable to do it because somebody else won't cooperate, they're not at fault. Great, thank you, Simon. Just before you head off, Simon, sure,
there are these other standards
around of smoke detectors and energy efficiency that could potentially have effect on landlords. Can you give us a quick update on where we are with those?
Yeah, as you may, there's been a lot of press in the last couple of weeks about new rules on fire and smoke detectors in housing across Scotland. The good news for landlords is that doesn't change anything for them. They've already had these standards since 2013 for fire alarms and 2015 for carbon monoxide detectors. We are applying the rules that apply to landlords for everyone else. So it makes no change to them, no additional work or impact on them.
Yeah, I think we really need that. There have been cases of tenement fires recently, and they're almost impossible for owners to deal with. And a quick update on energy efficiency, Simon.
There is an intention, as I understand, there would be a progressive minimum standard in private rented properties, E, then D, then C, and so on. There's an existing standard if there's a social landlord in the building for their part of it, which is broadly high. It depends on the type of property, but it's broadly high D, low C for properties. But the aim would be for that to rise up to B by 2032.
If people are interested in looking at energy efficiency in their properties, we've got a lot of information on the Under One Roof website on energy efficiency. And I'll just draw people's attention to that. Yes. Look, Simon, that was great. I hope you're able to get back in for the Q&A at the end of all of these presentations. And
hopefully, yes.
Thank you so much.
If people think of things later, or you know, I'm happy to share my email address and people can contact me.
And people can jump in and put things on the Q&A or write things in comment. We really look forward to seeing them. Simon, thank you so much again.
Thank you, Annie. Thank you.
I'd just like to turn now to our next guest speaker, who is Robert Storey. Now, Robert Storey is a former director of G3 Consulting Engineers, and he's been involved with these CDM regulations since before they were invented, I think, actually. And he doesn't just know them inside out, but he's been training people like housing associations on these things. And since he's stepped back a bit from doing all these things on a full-time basis, he is in fact advising domestic clients like yourself. So he is the perfect person to ask these questions. Thank you for being here, Robert. I'm really pleased that you're here. So, Robert, what is CDM? It's not Cadbury's Dairy Milk, is it?
No, it's construction design and management regulations. Bit of a mouthful, but the regulations were brought in 1995, and they were there. They're there basically to try and improve the safety in construction and for construction work. And so the regulations were, the idea behind them is that there's some thought given to the processes of construction work. Take that one back a bit, but the process of construction work and some planning, and also to involve competent people as early as possible in the process, right. That being competent contractors, etc.
Yeah, I mean, this is what we say to, get professionals in at an early stage. It will save you money in the long run. And I think you're also going to tell me it could save lives as well, aren't you? So.
Absolutely. I mean, and construction is one of the high-risk workplaces, as we all know. Construction sites 4 times more likely, to have an injury in a construction site than you are in any other workplace. Yeah.
Okay. But if landlords are arranging for someone to clean the gutters or paint the windows, that's not construction, is it?
Well, I'm afraid it is. The definition for construction work under the regulations includes maintenance and things like window replacements, drainage repairs, roof repairs, even painting to a certain extent. So if you're, the definition is quite broad, and it's when you're employing anyone to do work on your property that's probably the best way to think of construction work. It includes maintenance, for instance, even includes landscape work. So it's quite broad, the definition.
Oh, right. So somebody out the back, grass cutting, you need to keep an eye on them as well. So we do know that this is a particular issue for landlords because they're classed as being non-domestic. Can you just unwrap that issue for people, Robert?
Yes. It is, it's quite an important thing to understand, because the regulations did have a kind of a late amendment to them when they were drafting them, to ensure that domestic clients are not caught up with the full, if you like, full weight of the regulations. A domestic client under the regulations is someone who's doing work to their home, or a close relative's home.
Okay, so a landlord who's renting this out, it's not domestic.
Correct.
Basically.
It's not domestic. So because it's not his own home, and right away you fall into the non-domestic or commercial client bracket, and that really means that the full regulations and the duty of the client is your responsibility, and you can't delegate that. It's something that cannot be delegated.
So what does a landlord do if there's a common repair that's got to be carried out and the other owners are just saying, look, you sort it? I mean, what's the landlord do to get the repair done, to get good value and keep themselves safe? Safe from the law as much as keeping the builders safe, I suppose, So domestic clients can get a leaflet from the Association of Project Safety, is the one that's shown up in the slide just now, which will keep them right. But for landlords, as I say, they fall into the non-domestic category. And there is a pamphlet, a leaflet, which is only 6 pages long, but it's easy. It's quite an easy read. And an HSC pamphlet will explain what a landlord should do. But in a nutshell, really, read that pamphlet and just make sure you appoint what's known as a principal contractor, and that has to be in writing. So we've got a few words coming in here that might seem a bit odd to people. So you've got a principal designer. I mean, we all think about designers doing artistic things, but you've got a designer here and you're talking about them in terms of health and safety.
Yeah, that's right. It can be quite confusing at times. The designer, the principal designer, is very much a CDM regulation, a defined role. It's a regulatory role. It's not. It will normally be one of your designers. So if you were getting work done, for instance, alteration work to the property, and you have an architect or an engineer, it would be the lead designer
Okay.
We could take on the role as principal designer.
Okay, then, right. And then you also use the term principal contractor.
Yeah.
So is that just the head contractor that you're talking about? And so, I mean, if it's just a painter, the painter would be the principal contractor. But if that painter were to employ, say, a scaffolding company to come and do something for them, it would still be the painter's responsibility. Is that a correct interpretation?
Correct. Yeah, that's probably the easiest way to look at it. The important thing, though, is that as a client, as a landlord, you should appoint that principal contractor. Right.
Okay.
So you have to think about when you come to engage even a painter, that he is aware that you expect him to work as the contractor who's responsible for health and safety.
Okay, so what's the best way of doing that and the easiest way of doing it?
Right, well, as I say, for very small scale works, the best way is really to make sure that your appointments are in writing. But I would suggest that really for any landlord who's got properties that he's likely to do a bit of work to over a period of time, you should think about taking some CDM advice.
By the way, just before everybody jumps on chat to say, who's that organisation you're talking about? We'll put these things in a handout, which you'll be able to download if you just just check the handouts tab. There'll be something there. So suppose it's just a small job and you've just got one or two properties, appointing someone to do something for you, it just may not come up that often that it seems worthwhile to people. What? Go straight to a contractor, for instance. How do they know that contractor's going to do things safely, I suppose?
Right. So the point I was going to make there is that no matter the size of the job, if it's construction work, as the regulation defined it, then it must comply with the regulations. So beware of that. It's not just the size, because even a small piece of work can be quite risky. Cleaning a gutter on a roof, for instance.
Okay.
So the main thing is make sure that when you consider the CDM regulations when you make that appointment.
Presumably, I mean, John and I were talking about this last week, that you also put that in your signed acceptance of the quote as well. This work will be done in accordance with the regulations. Yeah.
Yeah.
And that would be enough for somebody to have discharged their responsibilities, would it?
The key points is to involve competent people as early as possible. So make sure the appointment's for the principal contractor. You make that appointment. That's a contractor that understands the regulations. Yep. And if you're using designers, then to appoint a principal designer. And that is a designer that understands the regulations. And that should keep you, those are the main points, I think.
And so if people are doing, as we suggest, taking on professional help for anything that's getting on to be a decent sized repair, is to say to that person, architect or surveyor or engineer, maybe even like yourself, Robert, you are going to be my principal designer and take care of health and safety. Right. Okay.
Right,
what happens if people don't do this? What are the penalties?
Right. Well, that really is the crux of the matter here, because the penalties are there's unlimited fines for breach of the regulations. It's unlimited fines, and there is potentially a prison sentence. And
we've got this situation as well where we've got this kind of mixed group of owners. We've maybe got one landlord in a close, all the rest are owner occupiers, because there's one non-domestic client there. Is the whole thing a non-domestic job, or is it a domestic job if one of the other owners lets the contract?
Right. So this is quite tricky, because and if you have a tenement that's mainly full of domestic clients, but you have maybe one landlord, I'm afraid my advice is it will be treated. The HSC will treat this as a commercial project. Any other point of view, you may want to pay the contractor individually. There could be several clients under the contract. There can only be one client in terms of the HSC. So the owners must appoint one person or create one body to be their client. Yeah. And if you think about it, then that one person can't comply with the domestic criteria, because he's by definition organising work on a property that he isn't living in, therefore becomes a commercial client.
So I think effectively, there can hardly be a tenement in Scotland that doesn't have mixed tenure these days.
Yeah.
Everyone involved in tenement repairs, and not least because they're big properties and people are often working at height, needs to think about the health and safety aspects and get that written into the contract from the get-go. I think that's what we're saying, isn't it?
Absolutely. But what I've got to say is that there usually isn't a lot to do. There's not a lot more for you to do. There's more responsibility if you don't do it.
And I suppose if someone's prepared to take a risk with their own life on something, they certainly don't care about your property to do a decent job on it, I would say, you know.
Yeah, well, we all know that's why the regulations had to come into place.
Yeah.
I mean, because people will cut corners at their own risk, as we've seen with some of these slides earlier on. It's quite ridiculous what people will do to save money at times.
Yeah.
Okay, Robert, look, thank you very much on that. I'm going to get you to come back at the Q&A. I think there probably will be some questions from people, and hopefully we can get you back on again to try and deal with some of those. Thank you very much.
Right, okay, will do. Look forward to that.
Great. While we are waiting for all the other presenters to come back in for the Q&A, and I see they've all been responding to you, it's just been brilliant. There are 2 webinars coming up, which I think will be of great interest to you, given all of the comments that have been made. So next week's webinar is going to be on how you get your uncooperative co-owners to cooperate. It's a bit of a tongue twister, isn't it? But we're going to have Jim Ball, who is a solicitor, and Jim also does a lot of work with the First Tier Tribunal. He's going to be with us. And we're also going to have Graham Boyack from Scottish Mediation with us next week. So we're going to be talking about how you start off persuading and trying to understand your co-owners to get them to do things, to how you actually enforce things with them. So that's next week. And if you're registered for this webinar, then we will be sending you a link on a couple of days beforehand, but it's same time, same place. Now, the other questions that were coming up, we will deal with some of these. And I think Dorothy has been chatting with some of you on them, but they are on the question of the factor's role. And this is going to be coming up. I haven't quite got a time fixed yet. But it is going to be one of these Wednesdays anyway. And I'm going to have a commercial factor and a factor from one of the a housing association factor probably coming on to talk about how factors earn their fees, which I think is one of the big questions that you all have. And we'll also be trying to tackle some of the questions of common insurance in that particular webinar as well. So we're going to come to your questions now, and I'm going to start off with questions for Simon, because I know Simon has got to go off. He has another presentation he needs to be doing for one of his other voluntary activities. So I know you picked up on some of these questions online, Simon, and we're answering them, but I think it might be useful just to go over them again for people who haven't been able to look at that.
Okay.
So we had a question from Jackie, and Jackie was effectively saying, how much proof does the First Tier Tribunal need?
Yeah.
You have been able to get common repairs carried out.
I think it's within any case where a landlord's going to a tribunal and the tenant's saying you should do X work on the house, and you're saying, well, I don't think I can do it for whatever reason. They are going to expect you to be able to show you made reasonable effort to do that. So I think that point is well made. It's no good just saying, oh, I know they wouldn't have agreed to it, so I didn't bother asking or anything like that. It's certainly worth engaging with stair committees. And I know we've talked in the past about owners who are not very cooperative about allowing landlords to be involved, but you need to show that you've done what you can. And I think that it's reasonable to expect that. You're potentially in an environment where the tenant is saying one thing and the landlord is saying another. So showing that you've done your best and been reasonable. That always, is a useful thing to be able to do when you go before any kind of panel like that.
Yeah. I mean, it's one of the things we say to people that when you're coming down to trying to enforce repairs is you need to keep copies of everything, all the correspondence you have. So whatever you're doing, keep copies.
Yeah. You don't want someone to say, well, if you'd asked me,
emails, notes of phone calls, all of those things, you need to have your kind of evidence trail, and you may need it to take a co-owner to court. You may need it to defend yourself at the first tier tribunal. Have evidence. Now, there was a kind of supplementary to that question, Simon, from Lynn, who was saying, well, look, what if another co-owner, another landlord comes in saying, I can't afford it? Is that an excuse?
Yeah. No, I don't think that's an excuse for an owner, to be honest. If you own a house, you should expect to have to pay to look after it, the same as you would with a car or a dog. And I know you get situations where people maximise their mortgages, or we get older owners with limited income, and we need to confront. But really, I think it's one of the big things that came out of the parliamentary working group. We need to move to this culture where people accept, if I own a house, there's an ongoing responsibility to take care of it. And simply saying, well, I can't afford to do it. It's like any other business. You wouldn't say I can't afford to meet my statutory obligations. You need to be able to do that in order to be able to run the business. Yeah.
So that is particularly not an excuse for.
No, I do think that if that doesn't mean you have to give a blank check to any project, no matter how absurd it is. You're entitled to say, actually, no, this isn't a sensible solution to this. I'm going to use my vote in that way because I don't think it's the right solution to this particular issue of disrepair. So I don't think the fact that you would expect a landlord to be in favour of work needed to meet the repair and necessarily means that they have to just say yes to everything, no matter how strange it might be.
So reasonable.
Yeah, reasonable. It always comes down to reasonable. And some will always say, what's the definition of reasonable? And it isn't in the legislation, but it usually means the test usually applies. What would a fair-minded third party think? So try and put yourself in the position of somebody else who isn't involved, hasn't got interest. What would they think of what I'm doing? Would they think I was behaving reasonably? Yeah.
I should just say, actually, we have been shorthanding a bit here. We've talked about landlords and owners. And when we say owners, we're shorthanding for owner-occupiers.
Yes.
You are obviously all owners, but so we have been shorthanding. Apologies if that confused anybody, particularly in the discussion that Dorothy and I were having. Simon, just to finish off, I think the last question that came in for you was about the hard wiring.
Yes, Barbara.
Detectors. Do you just want to answer that one verbally for the record?
Yeah. The question was, do they have to be hardwired? And the answer is no. You have a choice between one that's connected to the mains for its power supply, or one that is a sealed unit with a long life battery for its power supply. The only thing that's not allowed are the things where you can take the battery out and replace it. They do have to be interlinked, so they have to be able to communicate with each other, but that can be done wirelessly through radio or internet or something like that. That's all acceptable. And that's the same rule will apply to both homeowners as currently applies to landlords.
Okay, thanks, Simon. I think that's all the ones for Simon, unless somebody else has spotted one that I haven't yet seen. They will.
I can hang around for a bit anyway. Yeah.
There's a private presenters chat. They'll be on to me about it. Don't worry. Okay. Let's turn to some questions that came in about CDM. There's one here, Robert. How do you know that a contractor is acting in accordance with CDM?
Yeah. You're really not expected to know the contractor's duties, and depending on the type of work that's been arranged, these can vary. So you're not expected as a client to be the expert there. So if that was the basis of the question there, I'm not sure if that was it. Jim, it was asking whether if that was his concern, is he expected to know that? No, I think the contractor himself, provided he's made a commitment to you to comply with the regulations, and you have went to the effort, if you like, to make sure that he will, that he's made that commitment to you, then I think that will cover you in a lot of cases. We're talking mainly here about small scale works. I think, it's small repairs, etc. So in that context, simply to make the inquiry, to make sure the contractor's competent. In other words, he's done it before. He's not. I think the concern would be, if someone were just to turn up at your doorstep and you arrange to do that, arrange for him to do work for you without making any inquiry about, his competence or whether he was making a commitment to you, then that would be the concern. So just make sure that you're asking those questions. Do you know what the CDM regulations? This is you asking the contractor. Do you know what's? Are you aware of your obligations, and are you making that commitment to me to comply with those, and put that in writing? And that, that's really what you're expected to do as a client. Yeah.
If people are seeking quotes, Robert, and they want to make sure that all the people who are quoting on a comparable basis, particularly with regard to kind of health and safety aspects, could they actually ask in the quote for people to state what safety measures they would be adopting?
Well, you could do, but again, you're not the one that's expected to make that judgment. And I think it would be unreasonable for you to try and make that judgment. I think there would be, if you got two quotes that were wildly apart, I think a reasonable person would ask, well, is this contractor taking the right precautions? And maybe then, if there was a huge difference and an obvious difference that it looked like he was cutting corners, I think you could ask the question. I think that's what prior to appointing a contractor, that's what, that's the kind of precautions you might want to take. A common sense approach, if you like, to is this contractor really pricing, are we comparing apples to apples? But no, I think it's fair to say that the regulations are aimed at the contractor, right? The client to take reasonable inquiry, but they're not expecting the client to police, the contractor, if they want to put it in those terms.
But it is worth just checking out whether that is what's affecting the quote.
Yeah. It's worth saying, as the work becomes more complicated and it's more large scale, we're not talking about simply, maybe repairing a bit of drainage or defective stonework or something. If it's more of a comprehensive piece of work, then you have to, as I said in the in the presentation there, you should really look through the HSE guidance and make yourself aware of what client's duties are, because they go beyond just appointing the contractor, and these become more onerous, I think, the bigger the scale of work. But it's still not that difficult to comply with, I would say, so that's probably the best advice I could give is read that HSE leaflet. It's the least you should do, I think.
And the advice on under one roof is, I mean, it's a bit of a rule of thumb, but I mean, we tend to say anything over £5,000, get a surveyor or an architect to help you, and that will make sure that they're going to take that responsibility and all that concern from you completely. Robert, there's another question here, and it's kind of it's going to link us into this role of factors, which I think we're going to come to Dorothy about. Is do factors need to follow construction design management rules?
Can I say, in my view, that it's the person arranging the work that's effectively the client. So if a factor is arranging work for you and appointing a contractor and bringing that on board, then yes, they are taking on that role. So they are acting as client. There can only be one client under the CDM regulations for any piece of work. So even if there's a group of a group of owners, there can only be one client that the EHSC will expect to take on those client duties. And if a factor is taking that on board, arranging the work, then he, I think, will be seen as the contractor, the client. So I don't think there's anything wrong with any landlords there who are a bit concerned about that, asking that question. Are you as a factor taking the client role? Because we know that that's required. I don't know if Dorothy wants to comment on that, but I think that's what I would expect.
Yeah, Dorothy, would you like to just jump in on this?
Yeah, I mean, I think it depends on the individual arrangement you have with the factor. So as part of your agreement with them, have you delegated that role to them? So it depends, whether that's part of your agreement with the factor, same way as, for example, fire safety obligations. Have you delegated those? Has to be clear.
Right. Okay. And there was just one other question on the CDM regulations, and that was saying, look, if owner occupiers had to abide by all of these, would it put them off carrying out work? Now, I suppose that's coming down, Robert, isn't it, to saying, well, look, is it going to be a lot more expensive to use a contractor who is complying with construction design management rules?
It shouldn't be, absolutely not. And if there was a significant saving by using a contractor that didn't comply with the rules, then I would be concerned about using that contractor. I mean, so that there shouldn't be an increase. These days, most contractors, most reputable contractors that do work to tenements are complying with the regulations. Will know what's needed to comply. So I don't think you're taking on additional cost by asking contractors to abide by the regulations. It's not worth the risk to do otherwise, I would say. Yeah.
I kind of know that ought to be true, Robert, but I was flicking back over the photographs on my phone as the storage had got too full, and I've got two pictures where there's a guy standing on the roof holding, with a rope around his waist, and he's got somebody else dangling off the end of that rope in the gutters, Robert. Two pictures, so it does happen still.
Yeah, well, back to the original question, would it cost you more? Would it cost you more than anybody else that's doing the work properly?
Yeah. And I just have to say, like I was saying when we were talking, if you've got people who are doing that, if they don't care about their own lives, they're not going to care about your property to do a decent job. And would you want to have something like that happen on your property? I think you just have to talk to your other co-owners and just say, look, we just have to make sure this is done properly. It's really the only way forward. Let's go back to some of these issues about factors now, Dorothy. Like I say, we are going to have a whole webinar on this, but there did seem to be a particular debate going on between people on chat about whether somebody who is an owner in the block, should they be able to charge a kind of admin fee for their efforts? Would that make them a factor? And other people saying, I don't think you should. What else have other people been saying to you about this particular issue in the consultation? How do you feel other people are going on this?
Charging is quite a difficult one, because at the moment we explicitly say that the fact that you don't charge doesn't mean you're not a factor. The Proven judgment has changed that somewhat, because that explicitly says, you need to be undertaking a factoring business and making a charge for that service in order to be a factor. So I'm really hesitant to comment on particular cases, because I don't want to sort of give people firm answers that they then rely on, and then there's some further difficulty down the line. But at the moment, my understanding of that judgment in the Proven case is that if you're not undertaking a factoring business, then you're not judged to be a property factor. But I think it illustrates why there is potentially a problem with the judgment, in that you can be carrying out some other sort of business and factoring and charging for it, but not be considered to be a factor. So not sure that I'm being very helpful in answering the question. I think individual arrangements between owners that are made to organise and maintain that stair as a self-factoring arrangement, we're not going to find that those people are factors.
Okay.
Because they're owners or owner occupiers working together to factor a stair, and we would probably never know about the percentage charge, but it is obviously a difficult, if everyone's in agreement, not sure.
Yeah. I mean, it's one of those grey areas which I think it would be great if the guidance and the regulations, when they come out, could try and deal with those. I think the more certainty people have, the more it would help, actually. I think that must be a clear plea from people. I just wonder, have you seen what the poll is saying on all of this? I wonder if you just want to reflect on what people are saying here, Dorothy.
So maybe Petra can help me just with the percentages. Does that mean that 27% of people?
I think that's going to be 27% of all of those attending. So
Right.
We've got about 41 people online here listening in. Hopefully you have all managed to say something if you wanted to and didn't have technical difficulties there. And if you did, let us know and we'll try and find a way quickly of you responding, or just write to Dorothy. Actually, that might be the easiest thing. So we've had 13 saying that individual owner occupiers should automatically be excluded from being a factor. More who are sort of a bit less decided about owners associations. It'd be interesting for people to come on chat who, those 5 who said, yeah, we shouldn't have individual owner occupiers as factors. There were 5 of you who didn't also say owners associations as well. Maybe it'd come on chat and say why you said that. We had 11 people who said anyone who carries out common repairs on an irregular basis. 11 who said anyone who does not charge for the service. That's the thing we've just discussed. And then 9 who said that landlords who acted following a majority decision of owners should not be regarded as being factors. And I mean, I've had an exception to the exception, that's where a landlord is the majority owner. So, I see 15 responses. People are still jumping in. Yes, please do. Please do. We will make sure Dorothy gets all of these. How are you kind of reflecting on all of that, Dorothy? Is that helping you in your consultation? Oh, we've lost Dorothy. My screen's doing odd things. I saw somebody jumped off, and the way my camera's situated, I didn't realize it was Dorothy we'd lost. I thought it was Robert. Right. We will get these things to Dorothy. Hopefully she can manage to jump back in again on things, because we were just going to start talking about the role of factors. Let's just have another quick go through the Q&A and the chat and see if there are any other questions for Simon or Robert here. We've got more people coming in talking about the charging issue. We've got probably about the kind of the steamrolling issue. Stevie.
That's an interesting one, isn't it?
Sorry, say again, Simon?
That's an interesting one, isn't it? Because in that example, the council doesn't have a majority. So I'm not sure, is that case where they've got a mandatory factoring role in the titles or something like that? But if it was a stair decision, you would think they wouldn't be able to steamroll.
Yeah. The particular comment, just to read it out to everybody, was their problem is that they have got a council owning 3 out of 8 flats, and they're trying to steamroller repairs, which they're not really too genned up on. And estimates only almost 3 times the quotes from private contractors. And the council only use their own contractors and estimates and won't get involved with any decent contractor whose prices are far better. So, yes, I think we have had these kind of issues come to us before, actually, where local authorities are trying to get things done. But I think where they are the minority, as in this case, I don't think I don't think they can do that, but do check, this thing about the kind of health and safety issues, and are the private contractors going to be doing exactly the same work as the local authorities contractors on things. I see Dorothy is still trying to get in and out of things here. This is always a problem with some connections on things here. Some of the other questions that were coming up in the Q&A, I'll maybe try and deal with some of these just now. Are factors obliged to carry out property surveys? I think the answer to that is, what does it say in the written statement that your factor has sent you? That's kind of your contract with them. And you need to go and have a look at that written statement. And if it says they will carry out property surveys, then that's what they ought to do. But I think in most cases, if you're going to get a proper property survey done, as we discussed last week, you could be talking about £1,500. I don't think that's something which the majority of factors will do from within the standard factoring fee. So I think if it is going to be in there, they will expect to pay for it. Then we also had questions about, do factors need training? Is this a requirement? At the moment, it is not a requirement that factors undergo training. However, I know that factors are looking at this themselves and are setting up training programs which all of their staff can undertake and do. And I think when you're choosing factors, I think it's going to be one of the questions you should be asking your factor is, what training have your staff had? And again, just don't go for the cheapest. Which I suppose brings us to the question of changing factors. And there is a kind of odd situation, isn't there, Simon, about some title deeds that say that you must have to have a certain specified factor.
Yeah, I think that Dorothy would probably answer better than me, but I do believe that there's provision that allows you to change the factor after a period of time, whatever the title deed say. I think it's normally 5 years, possibly a lot longer if the local authority built the house. I think there's a longer period for them. For some reason, I've got 30 years in my head, but I'm not confident that it can really be as huge a number as that. But yeah, so I think there are these, you get titles written saying that you must have so and so as a factor, but I think there is there's a maximum time that you can enforce that kind of legislation before people have the right to have a vote on the issue. Yeah.
I did see that, although we're having trouble seeing Dorothy, we seem to have a black screen, Dorothy, and I don't know if we can hear you. Do you want to try saying something? No, I don't think we've got Dorothy, sadly. She is typing things in on answering the questions though. So do have a look at the Q&A there for Dorothy's response to these things. Another question that we had, Robert, this is maybe something where we're starting to get into sort of owners' responsibilities as well, is if you have a factor, do you need to go and check the common areas yourself? I would say the factor isn't always on the spot to go and spot things, and I think they are dependent on owners reporting things to them for them to arrange repairs. Do you have any kind of view on that yourself, Robert?
Well, only in that each owner has a responsibility for the common areas and have a responsibility to maintain them. So I would have thought, yeah, yes, you have that responsibility to look at these areas and make sure they're well maintained. But other than that, it's that depends on the property. It depends on how formal that arrangement is. It's not always easily done, and you're not necessarily the best person to do it. So our advice when we're dealing with, I suppose we tend to deal with larger clients, is to arrange regular inspections and tenement properties. That would be my advice, is try and have in it a system or a cyclical system of inspection. Doesn't have to necessarily be by an engineer, but someone who you think is competent to do it. So it's regularly, do inspections of common areas. Absolutely, they do need. You can't always leave it to the factor, I would have thought.
Yeah. I mean, inspections and regular inspections was one of the proposals put forward by the Scottish Parliamentary Working Group, who are saying that it should be compulsory to have 5-yearly inspections of properties. And once you spread that cost over all the owners and over 5 years, it doesn't work out at being a lot. You're talking maybe, classical tenement of 8 flats, you may be talking about sort of, 45, 50, 60 pounds per owner over the course of the year. And that can probably save you lots of money by spotting repairs before they've caused a real crisis for you. And I would also like to see those inspections referenced in the home report as well, so that when you come up to buy a property, you've got a proper inspection there that tells you exactly what the condition of that property is. And you can choose between 2 flats and you start to choose the one that's going to need the least repairs. I think that it's important we really build that in. Right. I'm just having a quick scan through the questions to see whether we picked up on anything. I think we have a comment here. I'm not sure Dorothy's going to be able to pick up on it. She is trying to come back in again, but it's somebody making a comment that if an individual charges for arranging work, then they are putting themselves out as a factor. They should have proper professional indemnity insurance on things. So I think that's a point that Dorothy can take back in her consultation, I think. What else coming up? Liz is saying, should factors check with new owners what their surveys say, as they don't at the moment? So are you saying factors ought to be relying on the home reports as they come in? I think sometimes the home reports aren't that great. Come back on us, Liz, if I picked that up wrongly. Malcolm is coming in here on a point about the Royal Incorporation of Chartered Surveyors, Institution of Chartered Surveyors, requirement that surveyors undertaking reinstatement valuation for fire insurance purposes carry out a survey prior to doing their valuation. And he's saying that the guidance is for a maximum 5-yearly revaluation, so 3 yearly is sometimes recommended in a fast-changing construction market. Yeah, these valuations, as I understand it, they are for the rebuilding cost of a property, which is what you need for your insurance. That they are not always about condition. But that is, Robert, you may know about this, I'm not sure, but come in if you do.
Well, no, a valuation isn't necessarily an assessment of the condition of the property. That's true. I mean, so you have to be a bit careful with that. That the report has to have that aspect to it, if you like. There is a duty on anyone inspecting the property to highlight anything that's obvious, but unless the brief of the report is to carry out an inspection of the condition, then that you won't necessarily exclude that. It's difficult because it's difficult, but I think probably you'll find that most tenement owners now will have experienced the fact that when you come to sell a property, that the condition is often brought up as a matter that has to be looked into in a bit more detail. The building surveyors, valuers are becoming more, or in recent years, have become more sensitive, more cautious about any defects that they come across. All tenements, by their very nature, need to be maintained and inspected regularly. That's in the nature of a traditional tenement property. So if we're talking about the traditional sandstone tenement, they need to be regularly inspected and looked after, or they deteriorate, you know, and it will cost you more money in the long run.
Yeah, yeah.
Mm-hmm.
Yes, I mean, I just think get repairs done sooner rather than later. Stitch in time saves 9, and good inspections will help you find those stitch in time repairs. I see Dorothy is just coming in and answering a question. Thank you, Dorothy. You really are struggling to be with us. We're really grateful for it. I'm just spinning through the questions here. We seem to have quite a lot of them about the enforcement issue. Someone here saying other owners aren't agreeing to repairs. Why should I bankroll them? That is a good point, and I will pick up on that next week. But if you have got a majority of owners willing to take part in carrying out repairs, speak to your council and see whether they will offer missing shares. I'll pick that up a bit next week, but it's incredibly useful. An awful lot of local authorities do this. There's only very few that don't, aren't there, Simon? Do you happen to know?
I believe it's quite popular with local authorities because the feedback I get is that at the point of actually paying the missing share, and that which involves putting the charge against the property, the owner who can afford to pay will usually at that point find the money.
Yeah, yeah. I think Edinburgh, where they were doing this and were keeping count, you know, they said for every 10 missing shares orders they issue, they only have to go through one of them.
Yeah.
And this is why local authorities like it. And
But also, they're not organising it. You, the owners, own the project and control it. All they're doing is stepping in and assisting you.
Yeah.
So it's light touch for them, which is in everyone's interest.
Yeah. So if owners have got the majority of owners to agree and there are just a minority who don't, if the council will allow missing shares, then before you start the work, speak to the council and they will send out a notice to these reluctant owners to say, if we have to step in with this order, then you will not only have to pay the cost of the repair, but you'll also have to pay an admin fee and you'll have to pay 8% interest on it. And owners, very surprisingly, suddenly find ways of paying up. So I would definitely say speak to your local authority here once you've got that majority of owners agreeing. Jim, I'm not quite sure if I can get back to find your question again about exactly where you were with that, but that is one of the answers for you, I think. Is there anything else coming up? I think we've pretty much got there with everything, everybody. I think we'll be starting to lose you soon because we have gone almost 20 minutes over the time. I would just wrap up by saying thanks very much to all of our speakers for coming along today and doing their kind of after-hours stint. Thank you, Robert and Simon and Dorothy. I'm hoping you can hear us, Dorothy, for us to say thank you. We really do appreciate your valiant efforts and all your your keyboard skills as you try and keep up with everything. And I'd like to thank all of you landlords out there for all of your participation, asking us these questions and being here. And just to say, those of you who are letting agents, we think we might have found a way for you to get a CPD certificate. Check on one of those handouts. There's one there that will give you a link and hopefully this will work. And if it doesn't, you know how to get hold of us to let us know about these things. So thank you very much, everybody. The recording will be available tomorrow and we will send it to you. And any further questions, jump in next week or send us an email. And just thank you again, Simon, Robert, Dorothy, and Petra, who's been behind the scenes helping us keep all the technical wheels on the bus. Thank you very much, everyone, and goodbye.
Thank you. Bye.